and that there is no law that says that it must be signed by the Vice Chancellor or that the two persons must sign together. Equally contended that the document is dated contrary to the submission of learned claimant counsel. I'll peruse the said document and find first that the document on its first page bears the date, quote unquote, November 2020. Though the date on which same was executed by the person who signed was not indicated, it is expedient at this stage to say that I take judicial notice of the provision of Section 157 of the Evidence Act 2011 as amended, which gives the court the latitude to presume the fact that the date on the document to be the date it was made or executed once it is proved. See Okoye versus Dumebi, Achuze, Ezenagu, and others, Oti and Nwaneke. However, it must be noted that this power can only be exercised by the document where the document is proved and where the date on it is clear. The document in question has not been proved, especially in this instance where the claimant is challenging due execution of same. In the same vein, the date on the document, which is November 2020, is uncertain because it is not clear which particular day of November 2020 it was made. Since the document has not been proved and the date on it is unclear, this court cannot exercise its powers under Section 157 of the Evidence Act to presume that the document was executed on the date on it. The introductory part states that the management had an interface with the affected staff on 17th, 18th, and 23rd of November. Which of the date was the document executed is unclear. Will it be proper to state that it was executed on the 23rd of November? One of the dates they allegedly had an interface with the affected staff? That cannot be correct. It does apparent that the date of the document was executed and signed by the Deputy Registrar Establishment Secretary of the committee is unknown, and the court cannot speculate. Thus, I agree with the position of Learned Claimant Counsel that the said document is undated. As regards the contention that the document is unsigned, I must say that a perusal of the document shows it ought to be signed by both the acting Vice Chancellor as the chairman of the panel and the Deputy Registrar Establishment as the Secretary as shown at page 228 of the record. But the document was only signed by the Deputy Registrar Establishment as Secretary. It is true that there is no law that says that document must be signed by the Vice Chancellor. However, I must say that the fact that the space for the signature of the acting Vice Chancellor was left, as shown at page 228, has one connotation, and that is the fact that the signature of the acting Vice Chancellor, who is the chairman of the said committee, ought to be on the document for authentication. If it were not so, the space of his signature would not have been created. I do not think the space created for the signature of the acting Vice Chancellor is merely cosmetic. In my view, the acting Vice Chancellor was intended as one of the makers of the document who ought to sign for a complete authentication of the document. It should be noted that once we say that a document speaks for itself, we mean a valid document which has no legal defect in any way. See the case of Maku and Al-Makura and others. In my view, the absence of a signature of the acting Vice Chancellor as the chairman of the committee in the space created for a signature in the document is a defect which this court cannot close its eyes to. The authentication of the document is not complete without the said signature. The position of the law on unsigned document is settled and very clear. Admitting of no argument, such a document is inadmissible and unenforceable. The case of Omega Bank Nigeria Limited and OBC Limited. Paragraph AA, the Apex Court per Toby GSC of blessed memory held, and I quote, a document which is not signed does not have any efficacy in law. As held in the cases examined, the document is worthless and a worthless document cannot be efficacious, unquote. Cited Davidson and others and INEC, Aiki and Idowu, Abia State and Agbara. A document having not been signed by the acting Vice Chancellor of the first defendant as expected is thus not efficacious and authentic and thus discountenanced. Assuming the said document is even efficacious, I still do not think same can sustain the position of the defendants that the procedure for dismissal was followed. There is nothing in the said document to show that either the procedure and the condition of service of Kogi PSR as regards giving query and response to same was followed. Thus, even if it was countenanced by this court, it still does not support the claim of the defendant. As such, the document is not only incompetent, it is also of no use to the defendant's case. At any rate, I have discountenanced the document for not being efficacious. Be that as it may, the claimant ought to be confronted with the allegation of forgery of certificate and be allowed to make her representation to same in line with the PSR, procedure for dismissal and the condition of service, or in Kogise PSR, which are similar, ought to be complied with before the claimant can be dismissed. See Controller General of Custom and Others and Resolve, UI and Bassi, FMC Ido-Ekiti and Alabi, Derima and Rivers State Civil Service Commission. It must be borne in mind that the procedure for dismissal is contained in item 8, A to D of the Condition of Service Rule 030307 of the PSR are both rooted in the hallowed principle of fair hearing as contained in Section 36 of the Constitution, in order to ensure that an officer is not dismissed without fair hearing. In fact, claimant by her pleadings alleged that the procedure adopted denied her fair hearing in breach of the constitutional provision. Let me pause here to address the contention raised by the defendants in their joint statement of defense and in paragraph 7.0 of his final written address at page 302 of the record that the enforcement of fundamental rights is sui generis and is not applicable in this case. I must say that the position of the defendant is misconceived in the sense that claimant in this case is not seeking to enforce her fundamental rights. Her action is an unlawful dismissal from employment for failure to follow procedure and denial of fair hearing before she was dismissed by the defendants. As rightly submitted by claimant counsel in paragraph 2.6 of the reply on point of law, the provision of Section 36(1) of the Constitution is not limited to enforcement of fundamental rights proceedings, but it is applicable in every proceeding, including panel and so on, where the civil rights and liberty or obligation of a person is to be determined or affected. Claimant in this case has alleged that the determination of her employment was done in breach of her right to fair hearing. That should not in any way be interpreted to mean that she seeks to do a fundamental right enforcement proceeding. Right to fair hearing is a fundamental statutory requirement in Nigeria in respect of any investigation as expressed supra. In the case of Arobiake and NELMC citation provided, the court held that an administrative body may not necessarily comply to strict adherence of natural justice in the law court, but the rule of natural justice and fair hearing cannot be waived or compromised in all cases. Oyewumi JSC, in her contributory judgment in the recent decision of the Supreme Court in the case of Skybank PLC versus Mr. Adedoku Olusegun Adegu, is an unreported suit number SC/406/2018, a judgment that was delivered by the Supreme Court on 27th of February 2024, held entirely thus with respect to fair hearing on dismissal of an employee, and I quote, "It has been held that employers and public bodies are required by law at all times to act fairly towards people and matters under their charge in all circumstances. The law does not permit employers to act arbitrarily. The question of whether there was fair hearing during dismissal process is so weighty that where the court finds that an employee was not afforded fair hearing, it renders the dismissal wrongful, entitling the employee to damages. Having said that, an employer has a duty to ensure that internal inquiries process or investigation panel hearing process, which was set up to hear and determine the allegations against an employee, and based on which the employee was recommended for dismissal, was done within the dictates of the law. The dictate of the law as regards fair hearing is predicated on two main points. Simply put, they are that the employee must be given an opportunity to respond to allegations against him or her, and must have the opportunity to face his or her accusers as the case may be. Also, the person sitting in the investigative panel should not be the same person as his or her accusers. Where these have not been observed, it cannot be said that the employee was afforded fair hearing before the dismissal, therefore rendering the dismissal wrongful. It should also be pointed out that an employee can be given an opportunity to present a case in defense of the allegations against him or her orally or in writing, unquote. In the instant case as reason supra, there is nothing to show that claimant was given query in line with 030307 of the Kogi State PSL confronted with the allegation of forgery of certificate before her purported dismissal in line with the constitutional safeguard of fair hearing. The law is settled that employment, especially the ones clothed with statutory flavor, cannot be determined in breach of the hallowed principle of fair hearing. See the case of Olorun Toba Oju, this is Abdurrahim and others, ZD and Rivers State Civil Service Commission, NEPA and Arubieke. Thus, compliance with the dictate of the law as regards fair hearing is paramount in the dismissal of the employee. Failure of the defendants to give claimant fair hearing before her purported dismissal is fatal to the case of the defendants and has an abysmal effect on the purported dismissal. I bear in mind the submission of defense counsel in paragraph 7.1 of his final address, that the claim of claimant that she was cleared after thorough investigation by the university management confirming her certificate does not hold water because there is no document to that effect. Documents in law speak by themselves and not through any other means. The content of a letter dated 11 December 2018 is clear, and the name of the claimant is on the list therein as number 13, wherein was stated under the recommendation column thus, quote, having obtained and submitted her original certificate, she was recommended to be cleared by the council, unquote. As reason supra, the defendants, particularly the first defendant in their pleadings, or at any point did not deny authoring the said document, neither did they challenge the authenticity of same. I must not forget to address the contention thrown up by parties in the address as to whether the defendants have proven the allegation of forgery beyond reasonable doubt, and whether same was specifically pleaded with particulars as required by law. The requirement that a party who alleges a criminal allegation in his pleadings must give particulars of the crime alleged and also prove same beyond reasonable doubt is one that case law authorities acknowledges. See Talek Drugs Company Limited and Onampa, Biko Nigeria Limited and another, Electronic Connections Limited. Therefore, it is not sufficient for a party to make a blanket allegation of crime without giving full particulars of crime allegedly committed. The question that agitates my mind at this stage is whether when the law requires the particulars of crime be given in pleadings, is this requirement met only when there is a separate part of pleadings headed, or say part of the pleadings headed quote unquote particulars? I do not think so. So long as what makes up the crime is given in the pleadings, just so that the allegation is averred clearly in a way that if the party alleged is to defend, he or she will know what to defend. The requirement, in my view, is met. See the decision of this court in the case of Babatunde Ajala and Right Park Company Limited is an unreported suit number LICN/LE/432/2013, a judgment delivered on 28th of January 2019 at paragraph 37 and 38, where the court held that it is not compulsory to head a paragraph particulars of negligence before negligence can be said to be specifically pleaded, and that the requirement of specifically pleading negligence is met if sufficient details of negligence is given for the party involved to know what he or she is to defend. In my humble view, the facts averred in paragraphs 3 to 6 of the joint statement of defense of the defendants contain sufficient particulars of the allegation of forgery of certificate of fraud made against claimant in such a way that she knows what to defend, especially as they clearly avert that she still had 2 carryover courses to write when she was issued the certificate. Thus, I'm of the view that they have sufficiently pleaded the particulars of forgery alleged. To hold that they have not specifically pleaded forgery or fraud because they have not headed the facts averred, quote unquote, particularly, is to enthrone technicality of substantial justice. And that is abhorred in the contemporary citadel of justice. Howbeit, as rightly submitted by Learned Claimant Counsel, the law places a burden on the defendants who have pleaded that claimant fraudulently obtained certificate of 15 March 2013 to prove the allegation beyond reasonable doubt. I have noted the submission of Learned Defense Counsel in paragraph 7.1 of his final written address. The result was referred to in the pleading as inconsistency and not forgery, and as such, the law does not impose any obligation on them to prove anything beyond reasonable doubt. He maintained further that the defendants throughout interchangeably referred to the act of claimant as illegality and inconsistencies in her spillover cause, which she knew before submitting the result of 15 March 2013. The response of learned defense counsel is clearly misconceived because in paragraphs 3, 4, 5, 6, and 7 of the joint statement of defense, the defendants conspicuously made the allegation of fraudulent obtaining certificate against claimant. In fact, in paragraph 3 thereof, they alleged that claimant, quote, fraudulently obtained and presented an inconsistent fake statement of result of her diploma course, unquote. In effect, the defendants clearly pleaded fraud or forgery of the certificate in those paragraphs. It is inconsequential that they use the word inconsistent interchangeably in other paragraphs. The moment they pleaded fraud or forgery of certificate, they bear the burden to prove same beyond reasonable doubt in line with Section 135 of the Evidence Act. See the case of Talek Dross Company Limited on Ankpa Supra, Biko Nigeria Limited, and another Electronic Connections Limited, Supra. It is also a title position of our law that although an employer is not obliged to give reason for termination of an employment of an employee, where he gives reason, the reason must be ascertained and justified by the employer. See the case of Union Bank and Salahuddin, Institute of Health, Ahmadu Bello University Hospital Management Board, and ANIP. See also the dictum of Tabaje Esina retired, the case of Shell Petroleum Company Limited and Chief Victor Sunday Olariwaju, where he stated those. The guiding principle which has been articulated and applied in many cases, including Olatuposo and ISA Council, is that an employer is not bound to give reason for terminating the appointment of his employee, but whereas in the case, he gives a reason or cause for terminating the appointment, the law imposes on him a duty to establish the reason to the satisfaction of the court. In the case, the appellant having given gross misconduct as his reason for respondent dismissal, he has the onus to establish that the respondent was indeed guilty of the alleged misconduct to warrant his dismissal. And in a case such as this, court must be watchful to ensure that in the investigation of proceedings of the domestic panel culminating in the employee's dismissal, the rules of natural justice were not breached, unquote. In fact, the court in the case of Olufiegba and others and Abdurrahim and others held that in the employment with statutory favor as in this instance, the reason for termination or dismissal as the case may be, must be ascertainable and in accordance with the condition governing the employment. The defendant who will want this court to believe that the reason given for the purported dismissal of claimant's forgery of certificate failed to substantiate the allegation before this court. Claimant in this case, by her pleadings and documents before the court which were not dislodged, was able to show that she did not fraudulently obtain the said certificate of the 15th of March 2013, which is the bone of contention. Rather, same was issued in error by the first defendant, who later issued her with another one after she had written the spillover cause, forcing the first defendant to withdraw the previous one and issued her a new one on the 15th of March 2015, which was used in updating her record. She was equally able to show that the first defendant, after complaints by her, cleared her of the said allegation. This fact was supported by the was supported by and consistent with the content of the certificate at page 147 of the record. Internal memo of 22nd January 2018, which is titled Reapplication for the Submission of my Original Diploma Certificate at page 148 of the record. Internal memo of 18 February 2019, titled Re-Complaint of Fake Result at page 151 of the record. Letter dated 11 December 2018, cases of concurrent omission at pages 152 to 153 of the record. The defendants never contested the authenticity or validity of any of these documents throughout this case. It is important that I point out that at this stage, the provision of Order 38 of Rule 33 of the Civil Procedure Rules of this court, which provides us, I quote, in any proceeding before the court, parties may by consent at the close of pleadings agree to a trial on records where they rely only on the documents and exhibit front-loaded, and thereby dispense with the need for oral testimony and or cross-examination, unquote. This court can rely on the content of any of the above documents in the absence of any objection to any of the documents front-loaded by the claimant, especially where the defendants have not filed any schedule of documents to show that they are objecting to any of the documents. Besides, as rightly submitted by claimant counsel in paragraph 3.21 of his final written address, there is nowhere the defendant denied issuing the above documents. From the uncontroverted contents of the above document, it is difficult for this court to find that the reason given for the purported dismissal of claimant has been proven. It is noteworthy that the defendants in their defense equally averred that the case of a claimant was presented to the state government on compassionate ground for possible pardon and included her name on the list of staff that be declared, but that the second defendant rejected her name and insisted that he was not convinced of the authenticity of her certificate. They relied on the copy of a final screening validation and appeal committee's report as relates to claimants and marked as Annexure 2, read paragraph 15 of their joint statement of defense at page 219 of the record. The law is on a firmer terra that it is the duty of a party who relies on the document to improve of its case to produce same before the court. See Federal University of Agric, Makurdi, and Adaipon, Lufthansa, German Airlines, and Balane. Allied to the above principle is the principle that where a document is pleaded and not tendered, the paragraph of a relevant pleading will be deemed abandoned. The case of Oba RAA, Oyediran Ibola, and Oba Libius and two others, the Supreme Court Pekuti GGSC, later CGN of blessed memory, held entirely others. I quote, about the other letter pleaded in paragraph 10 of the third respondent statement of defense, and which was not tendered, the law is simply that that paragraph of pleading is deemed to have been abandoned, unquote. See also the case of Takwa and Sheshi and another. Also, the court cannot speculate on the content of a document that is not placed before it. A court is not allowed to go outside the gamut of evidence before it to shop for materials upon which to use to decide a case before it. Lawan Abdullah and Bupa Wasa, Tasheri, Kara, and others. Okparaji and Ohanu. I perused the documents front-loaded by the defendants and found that the said documents pleaded as an issue 2. And the joint statement of defense of the defendant is not before the court. In fact, the only 3 documents front-loaded by the defendants, excuse me, with their joint statement of defense are payment receipt of NBF stamp and seal at page 224 of the record, report of interaction between the university management and staff who were allegedly involved in forgery or falsification of statement of result or certificate, and other related matters at pages 225 to 228 of the record, and a letter dated 26 August 2022 titled Repreaction Notice, unquote. The failure of the defendants to front-load or place the document pleaded and relied on in paragraph 15 of their joint statement of defense before the court has an effect on the averment in paragraph 15 of their joint statement of defense, which is the abandonment of the averment theory. Away from the above point, it is noted from the fact of this case as front-loaded by both parties in their pleadings that claimant was never issued a letter of dismissal after the purported termination based on the alleged forgery of certificates, as her salary was merely stopped and nothing more. The defendants, though claimant may not have made this an issue, it needs to be pointed out here that in this instance, where the claimant by employment is with status higher than that of an ordinary master servant, she ought to be communicated formally of her dismissal, like she was communicated of her appointment, as seen in the letter of her appointment. The Apex Court per Mohammed GSC, the case of PACN on Ofoelu, has sufficiently addressed the importance of proper communication of a notice to an employee, where he held as I quote, the respondent, in my view, is justified in his defense that he was not communicated the retirement. Even if he was, I think the communication was not done in accordance with the regulation as contained in Exhibit A. Proper communication of a message in law has its importance. Where there is a failure to communicate, a break in communication or lack of communication, the whole purpose of the message is completely defeated. If any step or action is taken by the issuing authority in spite of a fact of non-communication, non-service, the step or action taken goes to naught and amounts to a nullity in law, quote. Besides, the point must be made that constructive notice of termination or dismissal has no place in our law. Where there is no communication, the whole essence of a message is completely defeated, as an employee cannot be said to be aware of his or her dismissal without proper communication to that effect. See Advanced Maritime Transport Nigeria Limited, or Jogboli, and others, Mobile Producing Nigeria Limited, and another UDO. The point must be made that it is an essential part of the protection of employees that they must be informed of any possible breach of their rights, that the doctrine of constructive knowledge has no place in the debate as to whether dismissal has been communicated. It then means that an employee cannot be deemed to have knowledge or notice of his or her disengagement or dismissal until he or she has been expressly notified. The court went further that the correct view of the law is that an employment contract is brought to an end by a dismissal letter sent by or on behalf of the employer to the employee at his or her address and delivered to that address, and that it comes to an end on the date of such delivery, regardless of whether or not the employee was there at the time or later on that day or did not see the letter. See Udoha and other versus Silama, Gizda, CYE, and Barat, citation provided. The mere fact that the claimant was indicted by the screening exercise for possessing a fake or forged certificate cannot, without more, validly operate as severance of the employment relationship, because the claimant does not hold her employment at the pleasure of the defendants or at will. As public servant, she enjoys a special status. As such, she ought to be communicated formally of her dismissal, not just left hanging after the stoppage of her salary in 2019. It is against labor standards to leave an employee of claimant status hanging without being formally informed of her dismissal. Read the letter of dismissal to that effect, and which practice this court has taken judicial notice of from all similar cases which came before this court to be predicament of Kogi State public servants who were relieved of their employment by the government following the 2017 screening exercise. This unwholesome practice is not to be encouraged, especially in this instance, that the employment is cloaked with statutory flavor. I'm mindful of the fact averred by claimant in paragraph 32 of her statement of fact that she was never arraigned, tried, or convicted of any allegation of fraud or forgery. The above fact was admitted by the defendant by paragraph 2 of their statement of defense. There is no doubt the allegation of forgery of certificate, which is the reason given for the purported dismissal of the claimant, is criminal in nature. In the case of CBN and Dine, the Supreme Court held that where there is an allegation of criminal wrong against a person, the jurisdiction to determine the allegation is vested in the courts, and the exercise of such jurisdiction cannot be sought by any administrative tribunal. The Supreme Court went further that the reason is simple. Where there are serious allegations of crime like fraud and forgery, the matter is beyond the power of an administrative panel. It has to be pronounced upon by the courts of law, as the allegations are of serious, requiring proper judicial process in all their ramifications. The same vein, the Supreme Court in Awala and Nigeria Telecommunications held that any dismissal, suspension, or acts founded on criminal allegation by mere administrative panel is a nullity, void and of no legal consequence. Also, in the case of Wusupu and Civil Service Commission, the Court of Appeal held that an employment with statutory flavor is not easily defeated or determined by an allegation of criminal wrong without proof of the commission of the crime allegedly against the employee, which may require the conviction of the accused by a competent court. See the case of Nasarawa State University and Inekere, Anaja and UBA, the case of Ukeme and Civil Service Commission, Edo State, and others. However, the Apex Court in its later decision, in the case of FRN and Ngajiwa citation provided, created a dichotomy that where the employee commits an offense which imparts on his character and his ability to sustain the trust of his employer and his ability to continue to do his job efficiently and effectively, like fraud, stealing, bribery, and corruption, then the employer is at liberty to disengage the employee before conclusion of criminal proceedings. However, if the criminal offense is one that does not impart on the character or ability of the employee to do his job, then the employer has to wait for the conclusion of criminal proceeding before the disciplinary proceedings can start. And these are offenses like assault, murder, traffic offenses, and so on, in respect of which the employer has to wait the outcome of criminal prosecution before any disciplinary proceeding can be initiated or concluded by the employer. This decision, the decision of the Apex Court in the case of FR and Gajiwa Supra is the current state of the law as it relates to when allegation against an employee borders on crime and the extent of the power of the employer to discipline such an employee. The allegation of forgery of certificates is one that impacts on the character of an employee and the ability to do her job. And as such, the defendants cannot be compelled to charge the claimant before a court of competent jurisdiction before dispensing with the services of such an employee. More so, Rule 030411 of Kogi PSR provides that nothing shall prevent disciplinary action being taken or continued against an officer, whether or not criminal proceedings have been instituted with respect to such a person in any court of law in Nigeria or elsewhere, or about to be instituted or are contemplated. As such, it is not fatal for claimant not to be tried before a court of competent jurisdiction for allegation of forged certificate. The defendants could go on to dismiss her on the said allegation, provided that the laid down procedure is followed. At any rate, I have earlier in this judgment found that the laid down procedure was not followed. The Supreme Court in the case of Dufure Care and Pfizer Limited held that in a contract of employment, the element of unlawfulness arises where in carrying out the decision to terminate employment, the employer fails, neglects, or refuses to adhere to the laid down procedure in the statute. In the same light, the Apex Court in the case of CBN and Dine Supra held that where an employer acts contrary to the terms and conditions of a contract that enjoys statutory flavor, such act is null and void. However, Supra that the procedure laid down in either the condition of service or Kogi PSR was not followed by the defendant, as claimant was not given query and allowed to defend the allegation of forgery or certificate against her. I've equally held that claimant's right to fair hearing was breached when she was not allowed to defend herself with respect to the allegation made against her. In the case of Eze and Unijos, the Supreme Court held that any proceeding conducted in breach of right to fair hearing is a complete nullity. The same way, the Apex Court again in the Lefiagba and Abdurrahman Supra held that where a party is deprived of his livelihood and there is contravention of the law of fair hearing, termination or dismissal, as the case may be, is null and void, and as such cannot be allowed to stand. In view of the foregoing, I find and hold that Release 1 and 2 succeed. Claimant Vid Relief 3 is seeking for an order of injunction restraining the defendants, their servant agent, from preventing her from performing any of the functions and duty of our office, interfering with the enjoyment of her rights, privileges attached to her office. An injunctive order is an equitable relief which is meant to do justice to parties in the case. It is a well-established principle of law that injunction can be granted to protect the proved and existing right of a party. It is equally tried that an order of injunction capable of being granted must not be vague. The essence of granting a perpetual injunction on final determination of rights of parties is to prevent permanently the infringement of those rights and to obviate the necessity of bringing multiplicity of suits in respect of every repeated infringement. Thus, an order of perpetual injunction is a consequential order that must necessarily flow from declaration sought, which is the main order which cannot exist in vacuum. It is tied to the declaratory reliefs. The claimant in the instant case has successfully proved that the defendant failed to follow the procedure laid down in either the condition of service or Kogi PSR, and also breach her right to fair hearing. Claimant sought specific injunction to restrain the defendant and their agents as captured above. Claimant no doubt is entitled to grant of this remedy, having not been shown before this court to have misconducted herself or capable of the allegation of forgery or certificate of fraud. Thus, the defendants and their agents or servants are restrained from preventing claimant from performing any of the functions and duty of her office or interfering with the enjoyment of her rights, privileges attached to her office. Accordingly, Relief 3 also succeeds. I'll take Reliefs 4 and 5 together. Claimant by these reliefs is seeking for an order of reinstatement. By her uncontroverted avowment and evidence, her monthly salary is the sum of 41,000 naira. In the case of Kwara State Judicial Service Commission and Tolani Supra, the Apex Court held that where an employee's service service is protected by statute and it is wrongfully terminated or withdrawn, she would be entitled to reinstatement. It is equally firmly settled that upon reinstatement, claimant is entitled to be paid all arrears of salaries, including fringe benefits. This court has granted the declaration sought by claimant in Relief A that his dismissal is unlawful. It is only expedient for the court in the circumstance of this case to grant the consequential order of claimant to reinstatement and payment of arrears of her salaries. In Relief 5, thus I find and hold that Reliefs 4 and 5 succeed. By her Relief 6, claimant is claiming for the sum of 5 million as general damages. The court in the case of Akia 1, Nigeria Army Supra, held inter alia that in an action for unlawful termination or dismissal where claimant seeks relief of reinstatement which is granted, the issue of measure of damages for the unlawful, wrongful termination or dismissal or retirement becomes irrelevant, because upon reinstatement, claimant is entitled to be paid his arrears of salaries. Accordingly, granting the relief for damages after claimant's relief for reinstatement and arrears of salaries has been granted will amount to double compensation, which the law frowns at. It is in view of this that Relief 6 fails. By her Relief 7 is seeking for course of action. In the case of Shebi and Olaogun, the court held that a successful party is entitled to costs which he should not be denied except for good reason. Before now, the position has laid down in the case of Guinness Nigeria PLC and the Moki Supra, which was relied on by Learned Defense Counsel in his submission against the grant of costs. In his final written address, it is that it is an affront to public policy and unethical for a party to transfer the burden of the solicitor's bid to the opposing party. However, the position as seen in the decision of Apex Court in Mekuyi and Emirates Airlines citation capture held that such costs are at the discretion of the court once it is empowered by the rules of its court. The rules of this court, by Order 55, empowers this court to grant cause of action at the discretion of the court. The discretionary power of this court is to be exercised judicially and judiciously. Claimant in this case has not misconducted herself in any way and has succeeded in all the reliefs except in one. Therefore, in exercise of my discretion, I award the sum of 500,000 as cause of action in her favor. I so award. The position of the law is clear as regards award of post-judgment interest. It is the position of the law that post-judgment interest may be awarded even where it was not pleaded because it is statutory and is at the discretion of the court. The rules of this court regulates the discretion of the court by setting the rate or percentage at which such post-judgment interest may be awarded, and the percentage should not be less than 10%. I therefore, in exercise of my discretion in favor of the claimant, I award 10% interest on the judgment sum. Relief A does succeeds. Before I conclude this judgment, let me address the way and manner Learned Counsel for the defendants, Oyewumi Esquire, cited an authority in his final address. Learned Counsel in paragraph 3.2 of the address cited the case thus, Ihe Kwaba versus ACB Limited, Supra. And also in paragraph 6.1 of the same address, he cited the case thus, Basil Akbar and the state, Supra. Even though he had not prior to those paragraphs cited the cases in the address. First, let me pause here to say that where the authorities are reported, the name of the law report, the year, the volume, and the page must be cited by counsel. See the case of Ngadi and FR. Thus, a counsel citing cases has the duty to cite a case with clear reference and proper citation. However, contrary to the above duty, Learned Counsel merely cited the cases without clarity. He merely put the word supra, even though he had not cited the cases before those paragraphs. Counsel now cited the case of Ihekwaba in full, while he never cited the case of Basil Akbar versus the state in full at all throughout the address. The case of Mobile Producing Nigeria Unlimited and Edwin Orders. The court per ADA JCA, now GSC, explained the meaning of the word supra thus, in citing cases entirely. When the word quote and unquote supra is used in the citation of the case, it indicates something mentioned above, or that it has appeared in preceding pages of the text. Supra for short is a Latin word for above or previously used in the brief. I took time in the instant case to search for where Mr. Nwoko cited the case Edioha and Okorocha, and found that it was never cited in full anywhere in his brief before pages 4 and 6. He even omitted it completely from the list of 27 authorities at page 29 of his brief, despite the fact that he relied heavily on it in his brief. It was only at page 9, paragraph 4.21 of the brief that it was cited in full for the first time. When one appreciates the tedious and delicate nature of the job of a judge, counsel for the parties must take every care to lessen or facilitate it and not increase it. The case is cited in the law report as Right Honorable Megie Hedio and another, Zowele Richards, Anayo Okorocha, and others. The case of Ihedio and Okorocha and 2016 One Nigerian Law Report Part 1492, 147, unquote. The citation of the cases referred to in paragraph 3.1 and 6.1 referred to above are improper. And counsel is to desist from doing so. For the avoidance of doubt and the reasons earlier given, I declare an order as follows. A, that the purported dismissal of claimant from the employer of the first defendant is in contravention of the provision of the condition of service and Kogi State PSR in breach of her right to fair hearing, and it is thus declared null, void, and of no effect, and hereby set aside. B, claimant is to be reinstated back to her employment to the position she was before the purported unlawful dismissal. C, claimant is entitled to be paid her arrears of salary, the sum of 41,000 naira monthly from September 2019 till when she's reinstated by the defendant. D, she's entitled to cost of 500,000 naira. And E, the judgment is to be complied with within 30 days from today, failure of which it will attract 10% post-judgment simple interest per annum. Judgment is accordingly entered. Parties, you are entitled to clean copies of this judgment, so I'll forward it to Lokoja. Very well. I rise from Lokoja.